X is a member of the Social Security System, SSS. In 2015, he died without any spouse or children. Prior to the semester of his death, X has paid 36 monthly contributions. His mother, M, who had previously been receiving regular support from X, filed a claim for the latter's death benefit. A. Is M entitled to claim death benefit from the SSS? Explain. B. Assuming that X got married to his girlfriend a few days before his death, is M entitled to claim death benefits from the SSS? Explain. Answer to letter A. M is entitled to the death benefits. Being the mother of X, who was single and without issue, she is elevated to the status of sole beneficiary, Section 8, letter K of RA 8282. Answer to letter B. In view of the marriage of X to his girlfriend, M is deemed restored to her secondary beneficiary status. Hence, X's-wife will be his primary beneficiary until she remarries, provided she was living with him at the time of his death. Section 8, letter K, RA 8282. Yolanda Signey versus SSS GR 173582. Define, explain, or distinguish the following terms. A. Just and authorized costs. B. Seasonal and project employees. C. Strikes and lockouts. D. Bona fide occupational qualification. E. Grievance machinery. Answer to letter A. A just cause is a fault-based ground for dismissal under Article 297 Labor Code, whereas an authorized cause is a non-fault ground for dismissal under Articles 298 and 299 of the Labor Code. Letter B. A seasonal employee is one engaged for the duration of the season for which he has been engaged, whereas a project employee is one whose employment is coterminous with a specific project or undertaking for which he has been engaged, provided its scope or duration was made known to him upon engagement. Article 295 Labor Code. C. Strikes are carried out through temporary stoppage of work, whereas lockouts are carried out through temporary withholding of work. Article 279 of the Labor Code. Letter D. A bona fide occupational qualification is an occupational requirement based on quality or attribute. It is valid if it serves a legitimate business purpose, it is work-related, and its possession enhances an employee's productivity at work. Star Paper Corporation versus Symbol et al. E. A grievance machinery is a contractual dispute resolution mechanism for all grievable disputes. It is a mandatory provision of a collective bargaining agreement, without which it cannot be registered. A, B, and C were hired as resident doctors by Medical Center. In the course of their engagement, A, B, and C maintained specific work schedules as determined by the medical director. The hospital also monitored their work to supervisors who gave them specific instructions on how they should perform their respective tasks, including diagnosis, treatment, and management of their patients. One day, A, B, and C approached the medical director and inquired about the non-payment of their employment benefits. In response, the medical director told them that they are not entitled to any because they are mere independent contractors, as expressly stipulated in the contracts which they admittedly signed. As such, no employer-employee relationship exists between them and the hospital. A. What is the control test in determining the existence of an employer-employee relationship? B. Is the medical director's reliance on the contracts signed by A, B, and C to refute the existence of an employer-employee relationship correct? If not, are A, B, and C employees of Medical Center? Explain. Answer to letter A. Under the control test, the person who exercises labor law concept of control, actual or reserved, is the employer of the person over whom he exercises it. Labor law concept of control is control over means and methods of performance. Orozco versus CA. Philippine Daily Inquirer and Magsano. TR 155207. Answer to letter B. No, the medical director is not correct. Employer-employee relationship is a question of both law and fact. Law provides its cognitive significance, whereas evidence gives its out there representation. Being a matter of law and evidence, it cannot be the subject of stipulation. A, B, and C, who are not medical specialists, are the employees of Medical Center, owing to the means methods control exercised by the latter over them. Question 4. Mrs. B, the personal cook in the household of X, filed a monetary claim against her employer, X, for denying her service incentive leave pay. X argued that Mrs. B did not avail of any service incentive leave at the end of her 1 year of service and hence not entitled to the said monetary claim. A. Is the contention of X tenable? B. Assuming that Mrs. B is instead a clerk in X company with at least 30 regular employees, will her monetary claim prosper? Answer to letter A. No, X contention is not tenable. As the kasambahay, Mrs. B is entitled to service incentive leave, RA 10361. As such, she has the prerogative to use it, monetize it after 12 months of service, or commute it until separation from service. If she elects the second, she has 3 years from the demand for payment to avail of the benefit. Lourdes Rodriguez versus Park and Ride, TR number 222980, March 2017. Hence, not being a prescribed claim, its withholding is unlawful. Answer to letter B. Being a corporate employee, Mrs. B is a covered employee, and not being one of the less than 10 regular employees, as her employer has at least 30 regular employees, she is qualified. Hence, prescription being a non-issue, she is entitled to service incentive leave. Question number 5. Mrs. F, a sales assistant, is one of the 8 workers regularly employed by ABC Convenience Store. She was required to report on December 25 and 30th. Should ABC Convenience Store pay her holiday pay? Explain. Answer: no. ABC Convenience Store, being a retail establishment, does not have the duty to pay holiday pay to Miss F because she is one of his less than 10 regular employees. As such, she is disqualified by Article 94, letter A of the Labor Code. Question 6. D, one of the sales representatives of OP Incorporated, was receiving a basic pay of $50,000 a month plus a 1% overriding commission on his actual sales transactions. In addition, beginning 3 months ago, or in August 2019, D was able to receive a monthly gas and transportation allowance of $5,000 despite the lack of any company policy therefor. In November 2019, D approached his manager and asked for his gas and transportation allowance for the month. The manager declined his request, saying that the company had decided to discontinue the aforementioned allowance considering the increased cost of its overhead expenses. In response, D argued that OP Incorporated's removal of the gas and transportation allowance amounted to a violation of the rule on non-diminution of benefits. Is the argument of D tenable? Answer: no. This argument is not tenable. The principle of non-diminution of benefits, Article 100 Labor Code, strictly pertains to pre-promulgation benefits and not to post-promulgation benefits, such as subject allowance. Apex Mining Corporation versus NLRC, Insular Hotel Employees Union NFL versus Waterfront Insular Hotel Davao. If what is diminished is a post-promulgation benefit, the rule violated is the principle of grants. At any rate, the subject allowance has not yet ripened to a demandable right since its enjoyment was for a few months only, and the company did not intend to grant it permanently. Question 7. W Gas Corporation is engaged in the manufacture and distribution to the general public of various petroleum products. On January 1, 2010, W Gas Corporation entered into a service agreement with Q Manpower Company, whereby the latter undertook to provide utility workers for the maintenance of the former's manufacturing plant. Although the workers were hired by Q Manpower Company, they used the equipment owned by W Gas Corporation in performing their tasks, and were likewise subject to constant checking based on W Gas Corporation's procedures. On February 1, 2010, Mr. R, one of the utility workers, was dismissed from employment in line with the termination of the service agreement between W Gas Corporation and Q Manpower Company. Thus, Mr. R filed a complaint for illegal dismissal against W Gas Corporation, claiming that Q Manpower Company is only a labor-only contractor. In the course of the proceedings, W Gas Corporation presented no evidence to prove Q Manpower's capitalization. A. Is Q Manpower Company a labor-only contractor? Explain. Letter B. Will Mr. R's complaint for illegal dismissal against W Gas Corporation prosper? Answer. Letter A. Q Manpower Company, not being substantially capitalized and possessed with investment in the form of tools, equipment, machineries, or work premises, is a labor-only contractor. Relevantly, its apparent labor-only contractor status is confirmed by the fact that it does not control the means and methods of performance of the manpower it supplied. Since both essential element and confirming element are present, it is a labor-only contractor. Letter B. Yes, it will prosper. In labor-only contracting, the legal personality of the principal merges with that of its labor-only contractor, who is just its agent. Coca-Cola Bottlers Philippines versus De La Cruz et al. Hence, pursuant to the principle of merger of legal personalities, the former, as the real employer, can be proceeded against for legal dismissal despite the termination of subject contracting agreement. Question 8. Miss T was caught in the act of stealing the company property of her employer. When Miss T admitted to the commission of the said act to her manager, the latter advised her to just tender her resignation, otherwise she would face an investigation which would likely lead to the termination of her employment and the filing of criminal charges in court. Acting on her manager's advice, Miss T submitted a letter of resignation. Later on, Miss T filed a case for constructive dismissal against her employer. While Miss T conceded that her manager spoke to her in a calm and unforceful manner, she claimed that her resignation was not completely voluntary because she was told that should she not resign, she could be terminated from work for just cause, and worse criminal charges could be filed against her. A. What is the difference between resignation and constructive dismissal? B. Will Miss T's claim for constructive dismissal prosper? Answer. Letter A. A resignation is a voluntary self-termination when personal reasons cannot be sacrificed in favor of the exigency of the employer's business. Gan versus Calderma Philippines, January 17, 2013. In contrast, a constructive dismissal is a quitting because the employer makes continued employment impossible, unreasonable, or unlikely. Philippine-Japan Active Carbon Corporation versus NLRC, March 8, 1989. Letter B. No. Miss T's claims will not prosper. She was not placed in a situation that left her no option except to self-terminate. Instead, she was just given a graceful exit. A graceful exit is within the prerogative of an employer to give, instead of binding an employee to his fault or filing an action for redress against him. Central Azucarero de País versus Janet T. Ciazon, July 2015. Question 9. After due proceedings, the labor arbiter, or LA, declared Mr. K to have been illegally dismissed by his former employer, AB Incorporated. As a consequence, the LA directed ABC to pay Mr. K separation pay in lieu of reinstatement as well as his full back wages. While ABC accepted the finding of illegal dismissal, it nevertheless filed a motion for reconsideration, claiming that the LA erred in awarding both separation pay and full back wages, and instead should have ordered Mr. K's reinstatement to his former position without loss of seniority rights and other privileges, but without payment of back wages. In this regard, ABC pointed out that the LA's ruling did not contain any finding of strained relations or that reinstatement was no longer feasible. In any case, it appears that no evidence was presented on this score. A. Is ABC Incorporation's contention to delete the separation pay and instead order reinstatement without back wages correct? B. Assuming that on appeal, the National Labor Relations Commission upholds the decision of the LA, where, how, and within what time frame should ABC assail the NLRC's ruling? Answer to letter A. As to separation pay, the LS decision fails to state that there is a bar to reinstatement. Hence, he should have ordered reinstatement pursuant to the general rule prescribed by Article 294 of the Labor Code. Since the alternative relief of separation pay is an exception, it must be justified with a reinstatement bar. As to back wages, however, it cannot be deleted because it is a logical consequence of a finding of illegal dismissal. ICT Marketing Services versus Marifil, September 9, 2015. Hence, absent any reason for limiting or withholding it, it should be awarded, as it was awarded by the LA. Letter B. After the denial of the appellant's motion for reconsideration, the NLRC's decision in order of denial can be assailed under Rule 65 of the Rules of Court through the filing a petition for certiorari within 60 days from receipt of said denial order. Correction of error of jurisdiction resulting in the nullification of the assailed dispositions should be sought based on the NLRC's grave abuse of its appellate power amounting to lack of or excess of jurisdiction. Question 10. For purposes of prescription, within what periods from the time the cause of action accrued should the following cases be filed? A. Money claims arising from employer-employee relations. B. Illegal dismissal. C. Unfair labor practice. D. Offenses under the Labor Code. E. Illegal recruitment. Each item receives 1 point. Answer. Letter A. Money claims arising from employer-employee relationship shall be prosecuted within 3 years from date they become a legal possibility or can be judicially brought. Article 306, Labor Code. Article 1150, New Civil Code. Anabe versus Asian Construction. Letter B. Illegal dismissal shall be assailed within 4 years from complete severance of employee-employer relationship or date of salary or positional downgrade. Article 1146, New Civil Code. Orchard Golf and Country Club versus Francisco, March 18, 2013. Letter C. Unfair labor practice shall be brought by complaint under the Labor Code not later than 1 year from date of commission, Article 305, Labor Code. As to its criminal aspect, it shall be prosecuted within 3 years from date of finality of the ULP judgment, Article 305. Letter D. Offenses under the Labor Code shall be prosecuted within 3 years from date of commission, Article 305. Letter E. Illegal recruitment shall be prosecuted within 5 years if simple illegal recruitment and within 20 years if economic sabotage. Question 11. Briefly discuss the powers and responsibilities of the following in the scheme of the Labor Code. A. Secretary of Labor. B. Bureau of Labor Relations. C. Voluntary arbitrators. Letter A. Secretary of Labor. Ordinary powers, visitorial and enforcement, Article 128 Labor Code. Appellate review of compliance orders issued under Article 128 Labor Code. Review of CE orders per Article 272. Rulemaking, Article 5 Labor Code. And control and supervision. The Heritage Hotel Manila versus New H. Rain, HHMSC, GR 178296, January 12, 2011. Extraordinary powers, assumption power under Article 278, and suspension power under Article 292, letter B, both of the Labor Code. B. Bureau of Labor Relations, original jurisdiction, jurisdiction over intra-union and inter-union disputes involving national unions and like labor organizations, Article 232. Appellate jurisdiction, jurisdiction over appeal decisions of the DOL regional director in intra-union and inter-union cases, Article 232. Barles versus Bitonio, GR 120270. Voluntary arbitrators, traditional jurisdiction, jurisdiction over unresolved disputes arising from CBA interpretation or implementation, and unresolved disputes arising from the enforcement or implementation company personnel policies, Article 274. Jurisdiction by stipulation, jurisdiction over such other disputes as may be expressly conferred by a CBA or similar agreement. Question 12. Due to serious business reverses, ABC Company decided to terminate the services of several officers receiving fat compensation packages. One of these officers was Mr. X, its Vice President for External Affairs and a member of the Board of Directors. Aggrieved, Mr. X filed a complaint for illegal dismissal before the National Labor Relations Commission, NLRC, Regional Arbitration Branch. ABC Company moved for the dismissal of the case on the ground of lack of jurisdiction, asserting that since Mr. X occupied the position of Vice President for External Affairs, which is listed in the bylaws of the corporation, the case should have been filed before the Regional Trial Court. The labor arbiter denied ABC Company's motion and proceeded to rule that Mr. X was illegally dismissed. Hence, he was reinstated in ABC Company's payrolls pending its appeal to the NLRC. A. Did the LA err in denying ABC Company's motion to dismiss on the ground of lack of jurisdiction? B. Assuming that jurisdiction is not an issue and that the NLRC reverses the LA's ruling of illegal dismissal with finality, may ABC Company claim reimbursement for the amount it paid to Mr. X during the time that he was on payroll reinstatement pending appeal? Answer. The LA did not err. Even if the office occupied by Mr. X may have been listed in the corporate bylaws as a corporate office, it should have been shown that he was appointed to it by the Board of Directors. Absent evidence, Mr. X was a corporate employee. Hence, the tenurial issue he brought to the LA was not an intra-corporate issue. Cosade versus Broadcom Asia, February 5, 2014. Moreover, mere membership in the governing board does not make one a corporate officer. Unless elected as president, secretary, or treasurer, a member of the board would not qualify as a corporate officer. Section 24, Revised Corporation Code. B. ABC Company cannot claim reimbursement because Mr. X had nothing to do with the reinstatement given him. On the contrary, the company exercised its exclusive right to determine which type of reinstatement to give him. Had it informed him of the possibility of a reimbursement, he would not have chosen to be driven to penury at the end of the day, to a reimbursement by compulsion. In this case, the principle of unjust enrichment has no application. Hence, he can keep the salaries he received. Garcia et al. Versus Powell, January 20, 2009. Question 13. Mr. A signed a one-year contract with XYZ Recruitment Company for deployment as welding supervisor for DF Incorporated, located in Dubai. The employment contract, which the Philippine Overseas Employment Administration approved (POEA), stipulated a salary of US $600 a month. Mr. A had only been in his job in Dubai for 6 months when DF Incorporated announced that it was suffering from severe financial losses and thus intended to retrench some of its workers, among them Mr. A. DF Incorporated hinted, however, that employees who would accept a lower salary could be retained. Together with some other Filipino workers, Mr. A agreed to a reduced salary of $400 a month and thus continued with his employment. A. Was the reduction of Mr. A's salary valid? B. Assuming that the reduction was invalid, may Mr. A hold XYZ Recruitment Company liable for underpayment of wages? Explain. Answer to letter A. No, the reduction is not valid. There is a contractual breach. Applying Lex Ex Contractu or Lex Loci Celebrationis, Philippine law controls. Hence, the substantial character of the alleged financial losses must have been proven with financial statements duly certified by an independent external auditor. Mere announcement of losses would not suffice. The threat of retrenchment was just a scheme to conveniently effect the illegal substitution of the POE-approved employment contracts. Letter B. Yes, Mr. A may hold XYZ Recruitment Company liable for the payment of his wages under the rule that recruiter is solidarily liable for breaches of the terms and conditions of the POEA-approved employment contract, Section 1, Letter F, Rule 2, Book 2, POEA Rules and Regulation. Datuman v. First Cosmopolitan Manpower and Promotion Services, November 14, 2008. Question 14. Upon a review of the wage rate and structure pertaining to its regular rank-and-file employees, K Corporation found it necessary to increase its hiring rates for employees belonging to the different job classification levels to make their salary rates more competitive in the labor market. After the implementation of the new hiring salary, Union X, the exclusive bargaining agent of the rank-and-file employees, demanded a similar salary adjustment for the old employees. It argued that an increase in hiring rates resulted in wage distortion, since it erased the wage gap between the new and old employees. In other words, new employees would enjoy almost the same salary rates as K Corporation's old employees. A. What is wage distortion? B. Did a wage distortion arise under the circumstances which legally obligated K Corporation to rectify the wages of its old employees? Explain. Answer. A. A wage distortion is the elimination or serious contraction of the wage gap advantage enjoyed by one wage group over another of same wage region, provided such elimination or compression is caused by a wage law or wage order, Article 124, Labor Code. CBA renegotiation, Metro Transit Organization versus NLRC. Or merger, Manila Mandarin Employees Union versus NLRC, but not a promotion, NFL versus NLRC, July 21, 1994. Letter B, no, since the cause of the alleged elimination is not one of the recognized causes, as it was an adjustment of the hiring rate for new hires joining other wage groups. The elimination of the wage gap is not a wage distortion. It is rather clear that the increased rate would only be given to new hires and not to all the members of the wage groups they would be joining. Hence, the company has nothing to adjust or rectify. Question 15. On December 1, 2018, G Company, an organized establishment, and Union J, the exclusive bargaining agent therein, executed a 5-year collective bargaining agreement, which, after ratification, was registered with the Bureau of Labor Relations. A. When can the union ask, at the earliest, for the renegotiation of all terms of the CBA, except its representation aspect? B. When is the earliest time that another union can file for a petition for certification election? Explain. Answer. Letter A. Except for the representation aspect of the CBA, the other provisions can be renegotiated not later than 3 years from date of the CBA's effectivity, Article 265. Letter B. Another union can file a petition for certification election during the freedom period of the CBA, which is its last 60 days, Article 265. Question 16. W Ship Management Incorporated hired Seafarer G as bosun in its vessel under the terms of the 2010 Philippine Overseas Employment Administration Standard Employment Contract. On his 6 months on board, Seafarer G fell ill while working. In particular, he complained of stomach pain, general weakness, and fresh blood in his stool. When his illness persisted, he was medically repatriated on January 15, 2018. On the same day, Seafarer G submitted himself to a post-employment medical examination, wherein he was referred to further treatment. As of September 30, 2018, Seafarer G has yet to be issued any fit-to-work certification by the company-designated physician, much less a final and definite assessment of his actual condition. Since Seafarer G still felt unwell, he sought an opinion from a doctor of his choice, who later issued an independent assessment stating that he was totally and permanently disabled due to his illness sustained during work. Seafarer G then proceeded to file a claim for total and permanent disability compensation. The company asserts that the claim should be dismissed due to prematurity, since Seafarer G failed to first settle the matter through the third doctor conflict resolution procedure as provided under the 2010 POEA SEC. What is the third doctor conflict resolution procedure under the 2010 POEA SEC? B. Will Seafarer G's claim for total and permanent disability benefits prosper despite his failure to first settle the matter to the third doctor conflict resolution procedure? C. Assuming that the Seafarer G failed to submit himself to a post-employment medical examination within 3 working days from his return, what is the consequence thereof to his claim? Answer to letter A. In the event of conflicting medical assessments, the parties are required to select a third physician whose finding shall be final and binding on them under Section 20, letter B of the 2010 POEA SEC. The selection is consensual. However, jurisprudence has made it mandatory. Philippine Harmonia Ship Agency versus Eulogio Dumadag, GR 194362. Letter B. yes, it will prosper. The third physician rule has no application when the company designated physician exceeds the 120-day treatment period without making a final, categorical, and definite assessment. Here, he allowed 209 days to elapse without issuing a fit to work assessment or a disability grade. Alpines versus Elberg, Ship Management Philippines. C. Noncompliance with the 3-day reporting requirement results in the forfeiture of G's entitlement to disability compensation. Section 20, letter B, BOEA. SEC. Question 17. Miss A is a valuable coach with 5 years of experience in her field. Before the start of the volleyball season of 2015, she was hired for the sole purpose of overseeing the training and coaching of the university's volleyball team. During her hiring, the vice president for sports expressed to Miss A the university's expectation that she would bring the university a championship at the end of the year. In her first volleyball season, the university placed 9th out of 10 participating teams. Soon after the end of the season, the vice president for sports informed Miss A that she was a mere probationary employee and hence she need not come back for the next season because of the poor performance of the team. In any case, the vice president for sports claimed that Miss A was a fixed-term employee whose contract had ended at the close of the year. A. Is Miss A a probationary, fixed-term, or regular employee? Explain your reasons as to why she is or she is not such kind of an employee for each of the types of employment given. 5 points. Letter B. Assuming that Miss A was dismissed by the university for serious misconduct but was never given a notice to explain, what is the consequence of a procedurally infirm dismissal from service under our labor law and jurisprudence? 2 points. Answer. Miss A is a regular employee. She cannot be considered a fixed-term employee in the absence of a fixed-term employment contract, nor a probationary employee because it was not expressly communicated to her upon her engagement that her tenure was for 6 months, unless she survived pre-disclosed standards for regularization. When an employee is hired without being apprised of such standards, he is deemed a regular employee, regardless of the employer's intent to hire him as a probationary employee. Abbott Laboratories versus Alcaraz, July 23, 2013. Letter B. The violation of Mr. A's right to statutory due process requires the assessment of the university with nominal damages. The amount is $30,000 because a dismissal for failure to qualify is akin to a dismissal for a just cause. Abbott Laboratories versus Alcaraz. Question 18. When resolving a case of unfair labor practice (ULP) filed by a union, what should be the critical point of analysis to determine if an act constitutes ULP? Answer. The nature of an unfair labor practice is that it is a violation of workers' right to self-organization, Article 258 Labor Code. Kulili versus Eastern Telecommunications Philippines, February 9, 2011. An act, however unfair it may be, is not a ULP unless listed as such under Articles 259 and 260 of the Labor Code. Therefore, the critical point of analysis in a ULP case filed by a union is whether the act complained of is expressly listed as ULP under Article 259 of the Labor Code. Question 19. Because of dwindling sales and the consequent limitation of production, rumors were rife that XYZ Incorporated would reduce its employee force. The next day, the employees of XYZ Incorporated received a notice that the company will have a winding down period of 10 days, after which there will be a 6-month suspension of operations to allow the company to address its precarious financial position. On the 4th month of suspension of its operations, XYZ Incorporated posted announcement that it will resume its operations in 60 days, but at the same time announced that instead of closing down due to financial losses, it will retrench 50% of the workforce. A. Is the announcement that there would be a retrenchment affecting 50% of the workforce sufficient compliance with the legal requirements for retrenchment? Explain. Letter B. Assuming that XYZ Incorporated, instead of retrenchment, extended the suspension of its operations from 6 months to 8 months, would the same be legally permissible? If not, what are the consequences? Answer. Letter A. No. The 30-day notice requirement is a written notice that must be served on both the Department of Labor and Employment and the affected employees, Article 298 Labor Code. Hence, the posted announcement is a violation of the prescribed pre-termination procedure. Letter B. Temporary suspension of business operations under Article 301 of the Labor Code should not exceed 6 months. Otherwise, the suspension would ripen to constructive dismissal after the period expires. In such case, the company would be ordered to reinstate and pay back wages. Question 20. Discuss the differences between compulsory and voluntary or optional retirement, as well as the minimum benefits provided under the Labor Code for retiring employees of private establishments. Answer. A voluntary or optional retirement is a termination of employment based on a bilateral agreement to terminate employment at an agreed age regardless of years in service, or after a certain number of years in service regardless of age. It is a matter of contract. In contrast, a compulsory retirement is a termination of employment by operation of law. It is a matter of statute. Under Article 302 of the Labor Code, retiring employees shall be paid retirement benefits computed as follows: 22.5 days times daily rate times length of service. The 22.5 days consists of 15 days, representing half-month salary, 5 days of service incentive leave, and 2.5 days, representing 1/12 of 13-month pay. The full 22.5 days shall be used if the retiree is entitled to both service incentive leave and 13-month pay. Meantime, the 15 days must always be used.